इस वीडियो में हम लोग ऑल इंडिया बार एग्जामिनेशन का 15th क्वेश्चन पेपर सॉल्व करेंगे और ये है सेट डी। इस वीडियो में हम लोग आंसर के साथ साथ एक्सप्लेनेशन एंड रेफरेंसेस भी देखेंगे कि पार्टिकुलर जो आंसर है वो किस सेक्शन से किस एक्ट से उठाया गया है। और ये एग्जामिनेशन हेल्ड हुआ था 24 जनवरी 2021 संडे। तो पहला क्वेश्चन है, इंडेमनिटी कॉन्ट्रैक्ट इज डिफाइंड अंडर। राइट आंसर है ऑप्शन नंबर ए, सेक्शन 124 ऑफ द इंडियन कॉन्ट्रैक्ट एक्ट। Peak versus Gurney is a famous case related to option B, fraud. The Supreme Court invoked the principle of transformative constitutionalism in the case of option C, Nas Foundation versus Government of City of Delhi 2009. So what is transformative constitutionalism? इसे हम लोग समझते हैं। Transformative constitutionalism is a commitment to substantive equality and improving socio-economic conditions. The provisions of Indian Penal Code apply also to any offence committed by option D, all of the above. Any citizen of India in any place without and beyond India, any place on any ship or aircraft registered in India, wherever it may be. Any person in any place without and beyond India committing offense targeting a computer resource located in India। तो इसका ए बी सी तीनों ऑप्शन करेक्ट है, तो इसीलिए ऑप्शन नंबर डी हमारा राइट आंसर होगा, ऑल ऑफ द अबव। इसका रेफरेंस मिलेगा आपको आईपीसी के सेक्शन 4, एक्सटेंशन ऑफ कोड टू एक्स्ट्रा टेरिटोरियल ऑफेंसेस। Under the Patent Act, which of the following are not patentable? Option A, a method of agriculture or horticulture. Option B, a presentation of information. Option C, topography of integrated circuits. तो ये तीनों पेटेंटेबल नहीं हो सकते हैं, तो ऑप्शन डी हमारा ऑल ऑफ द अबव राइट आंसर है। और इसका रेफरेंस आपको मिलेगा पेटेंट्स एक्ट 1970 के सेक्शन 3 में, व्हाट आर नॉट इन्वेंशंस, ये टाइटल है सेक्शन 3 का। वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन विपो हैज़ रिप्लेस्ड प्री एग्जिस्टिंग। किसको विपो ने रिप्लेस किया? तो ऑप्शन नंबर बी, बिरपी, BIRPI। आइए ज़रा से इसके बारे में और हम लोग जानते हैं। द प्रीडिसेसर टू विपो वॉज द यूनाइटेड इंटरनेशनल ब्यूरियक्स फॉर द प्रोटेक्शन ऑफ इंटरनेशनल प्रॉपर्टी। ब्यूरियक्स इंटरनेशनॉक्स रियोनिक्स और ला प्रोटेक्शन डे ला प्रोप्राइटे इंटेलेक्चुअले with the French acronym BIRPI, BIRPI, which had been established in 1893, to administer the Berne Convention for the protection of literary and artistic works and the Paris Convention for the protection of industrial property. Anuradha Bhasin versus Union of India on 10th January 2020 relates to a challenge under Article 32 of the Constitution seeking issuance of an appropriate writ. Option A, for setting aside orders of the government by which all modes of communication including internet have been shut down in Jammu and Kashmir. Option A, correct answer है। Section 66A of the Information Technology Act was struck down under Article 19, Clause 1, Subclause A. Read with Article 19, Clause 2 in the case of, right option is option number D, Shreya Singhal versus Union of India. Article 145, Clause 3 of the Indian Constitution states that the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this Constitution or for the purpose of hearing any reference under Article 143 shall be, कितने जजेस होने चाहिए? तो ऑप्शन नंबर सी 5। और इसका रेफरेंस मिलेगा आपको आर्टिकल 145 में, जो कि है आर्टिकल 145 का टाइटल है रूल्स ऑफ कोर्ट एटसेट्रा। MC मेहता वर्सेस यूनियन ऑफ इंडिया 1986 श्रीराम फूड एंड फर्टिलाइजर्स केस रिलेट्स टू, राइट आंसर इज ऑप्शन नंबर ए, ओलियम गैस लीक। AK क्राइपक वर्सेस यूनियन ऑफ इंडिया रिलेट्स टू, राइट आंसर इज ऑप्शन नंबर सी, administrative discretion. Judicial control of delegated legislation may be exercised on the ground of doctrine of ultravires, malefides, exclusion of judicial review. ये तीनों हमारा सही है, तो राइट आंसर इज ऑप्शन नंबर डी, ऑल ऑफ द अबव. On and from the commencement of the Hindu Succession Amendment Act 2005, in a joint Hindu family governed by the Mitakshara law, conferring on daughter co-partnership status by substituting new section for. तो राइट आंसर है ऑप्शन नंबर ए, सेक्शन 6. सेक्शन 6 का टाइटल है डिवोल्यूशन ऑफ इंटरेस्ट इन को-पार्टनरी प्रॉपर्टी. Section 5 of Hindu Marriage Act relates to option number D, conditions of Hindu marriage. A marriage between a girl of 22 years and her maternal uncle's son of 23 years in accordance with the Special Marriage Act. Such marriage is option D, valid only in North India. The principle of res judicata is dealt under section 11 of CPC. So हमारा right answer है option number C, section 11. Section 14 of the CPC deals with option B, presumption as to foreign judgments. A, residing in Delhi, publishes in Kolkata statements defamatory of B. B may sue A, option D, either in Kolkata or in Delhi. और इसका रेफरेंस मिलेगा आपको सेक्शन 19 सीपीसी के सेक्शन 19 के इलस्ट्रेशन बी में. सेक्शन 19 है सूट्स फॉर कंपेंसेशन फॉर रॉन्ग्स टू पर्सन और मूवेबल्स, which provision under Criminal Procedure Code 1973 deals with the procedure to be adopted by the magistrate to record confessions and statements. Right answer is option number B, section 164. Attachment of property of person absconding can be done under which section of CRPC? Right answer is option number A, section 83 of CRPC. Magistrate may dispense with personal attendance of accused under which section of CRPC? Right answer is option number C, section 205 of CRPC. Section 265A to section 265L, chapter 21A of the Criminal Procedure Code deals with the concept of option D, plea bargaining. Security for good behavior from habitual offenders is dealt under which section? Option B, section 110 of CRPC. Section 105H of CRPC deals with what? Right answer is option number A, forfeiture of property in certain cases. Bar to taking cognizance after lapse of the period of limitation is dealt under section 468, बट हमारे ऑप्शन में सेक्शन 468 नहीं है, तो मे बी सबको मार्क्स इस क्वेश्चन में मिल जाएंगे. डिक्री होल्डर मीन्स ऑप्शन ए, any person in whose favor a decree has been passed or an order capable of execution has been made. राइट आंसर ऑप्शन ए है. और इसका रेफरेंस मिलेगा आपको सीपीसी के सेक्शन 2 क्लॉज 3 में. सेक्शन 2 क्लॉज 3 डिफाइन करता है डिक्री होल्डर को. वॉलंटरली थ्रोइंग और अटेम्प्टिंग टू थ्रो एसिड इज एन ऑफेंस पनिशेबल अंडर ऑप्शन ए, सेक्शन 326B of the Indian Penal Code. A is at work with a hatchet. The head flies off and kills a man who is standing by. Here, if there was no want of proper caution on the part of A, his act is option number C, not an offense. A, with the intention of causing Z to be convicted of a criminal conspiracy, writes a letter in imitation of Z's handwriting, purporting to be addressed to an accomplice in such criminal conspiracy, and puts the letter in a place which he knows that the officers of the police are likely to search. A has committed an offense under. Right answer is option number B, section 192 of IPC. सेक्शन 192 है फैब्रिकेटिंग फॉल्स एविडेंस. और जो ये पार्टिकुलर क्वेश्चन है क्वेश्चन नंबर 29, ये है इलस्ट्रेशन सी. सेक्शन 192 आईपीसी के सेक्शन 192 का इलस्ट्रेशन सी। Under Section 70 of the Indian Contract Act, where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. This principle is known as option number C, quantum merit. क्वांटम मेरिट का मतलब क्या होता है? क्वांटम मेरिट मीन्स what one has earned. Agreement is a promise or set of promises forming consideration to each other. So हमारा राइट आंसर है ऑप्शन नंबर ए। और इसका रेफरेंस मिलेगा आपको इंडियन कॉन्ट्रैक्ट एक्ट 1872 के सेक्शन 2 क्लॉज ई में। Under the Land Acquisition Act, the expression land includes option A, benefits to arise out of land, option B, things attached to the earth, option C, things permanently fastened to anything attached to the earth. ये तीनों करेक्ट है, सो हमारा राइट आंसर हो जाएगा ऑप्शन नंबर डी, ऑल ऑफ द अबव। Temporary occupation of waste or arable land procedure when difference as to compensation exists is provided under section 35 of Land Acquisition Act. So right answer is option number C, section 35. XYZ jointly promised to pay A an amount of rupees 50,000. Subsequently, XY became untraceable. Can A compel Z to pay? तो राइट आंसर है ऑप्शन नंबर ए कैन अंडर सेक्शन 43 पैराग्राफ 1। और सेक्शन 43 पैराग्राफ 1 क्या कहता है? इसका टाइटल है एनी वन ऑफ जॉइंट प्रोमिसर्स मे बी कंपेल्ड टू परफॉर्म। सेक्शन 43 पैरा 1 है इंडियन कॉन्ट्रैक्ट एक्ट का। Delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or disposed of according to directions of the person delivering them. This process is termed as bailment. Right answer option number B, bailment. और इसका रेफरेंस मिलेगा आपको इंडियन कॉन्ट्रैक्ट एक्ट के सेक्शन 148 में। सेक्शन 148 डिफाइन करता है बेलमेंट, बेलर एंड बेली। Section 14A, inserted by the Specific Relief Amendment Act 2018, relates to option number A, power of the courts to engage experts. In which of the following case the offense of sedition was in issue? Option A, Queen Empress versus Bal Gangadhar Tilak. Option B, Niharendu Dutt Mazumdar वर्सेस एम्पेरर। ऑप्शन सी, केदारनाथ सिंह वर्सेस स्टेट ऑफ बिहार। तो इसका करेक्ट आंसर है ऑप्शन नंबर डी, ऑल ऑफ द अबव। Deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs is an offense under section 295A. Right answer option number B, section 295A. Under Section 29 of CRPC, the court of a chief judicial magistrate may pass any sentence authorized by law except a sentence of death, imprisonment for life, imprisonment for a term exceeding 7 years. ये तीनों करेक्ट है, तो हमारा राइट आंसर हो जाएगा ऑप्शन नंबर डी, ऑल ऑफ द अबव। Provision regarding filing of suits by an alien under the Code of Civil Procedure is dealt under Section 83. तो राइट आंसर हो जाएगा ऑप्शन नंबर डी, सेक्शन 83। An order issued by court under Civil Procedure Code 1908 as per Order 21 Rule 46 for recovery of amount due to judgment creditor is known as option number B, गार्निशी ऑर्डर। तो ये गार्निशी ऑर्डर होता क्या है? तो आइए सबसे पहले समझते हैं कि गार्निशी का मीनिंग क्या होता है। गार्निशी इज अ थर्ड पार्टी हु इज इंस्ट्रक्टेड बाय वे ऑफ लीगल नोटिस टू सरेंडर मनी टू सेटल अ डेप्ट और क्लेम। आइए अब गार्निशी ऑर्डर को समझते हैं। Garnishi order is an order passed by an executing court directing or ordering a garnishee not to pay money to judgment debtor since the latter is indebted to the garnisher, that is, decree holder. It is an order of the court to attach money or goods belonging to the judgment debtor in the hands of a third person. Section 88, read with Order 35 of the Code of Civil Procedure 1908 deals with इंटरप्लीडर सूट। तो हमारा राइट आंसर हो गया ऑप्शन नंबर ए, इंटरप्लीडर सूट। The National Consumer Dispute Redressal Commission was constituted in the year 1988. So हमारा राइट आंसर हो गया ऑप्शन नंबर ए, 1988। The National Consumer Disputes Redressal Commission (NCDRC) is a quasi-judicial commission in India which was set up in 1988 under the Consumer Protection Act of 1986. Its head office is in New Delhi. What is the limitation period applicable to the three forums in entertaining a complaint under the Consumer Protection Act 1986? तो इसका राइट आंसर है ऑप्शन नंबर डी, 2 years from the date on which the cause of action has arisen. Mere illegality of the strike does not per se spell unjustifiability. Justice Krishna Iyer named the case. तो करेक्ट आंसर है ऑप्शन नंबर सी, गुजरात स्टील ट्यूब्स वर्सेस गुजरात स्टील ट्यूब्स मजदूर सभा. A workman, aggrieved by the order of what? May directly make an application to the labor court or tribunal for adjudication of the dispute, and the court or tribunal is empowered to adjudicate such dispute as it had been referred to it by the appropriate government. तो इसका राइट आंसर हो जाएगा ऑप्शन नंबर बी, डिसमिसल, डिस्चार्ज, रिट्रेंचमेंट और अदरवाइज टर्मिनेशन ऑफ सर्विस. विस मेजर मीन्स एक्ट ऑफ गॉड. तो राइट आंसर हो गया ऑप्शन नंबर ए, एक्ट ऑफ गॉड. According to classical doctrine of act of state in law of torts means an act of the sovereign power of a country that cannot be challenged, controlled or interfered with by municipal courts. तो राइट आंसर हो गया ऑप्शन नंबर ए. In torts, all persons who aid or counsel or direct or join in the committal of a wrongful act are known as joint tortfeasors. तो राइट आंसर हो गया ऑप्शन नंबर बी, joint tortfeasors. A is accused of waging war against the government of India by taking part in an armed insurrection in which property is destroyed, troops are attacked, and goals are broken open. The occurrence of these facts is relevant as forming part of the general transaction, though A may not have been present at all of them. Under which section of the Indian Evidence Act? तो ये आपको मिलेगा सेक्शन 6 में. ऑप्शन नंबर बी हमारा राइट आंसर है, ऑप्शन नंबर सेक्शन 6. सेक्शन 6 का टाइटल है रेलिवेंसी ऑफ फैक्ट्स फॉर्मिंग पार्ट ऑफ सेम ट्रांजैक्शन, और ये जो क्वेश्चन में इलस्ट्रेशन दिया हुआ है ये सेक्शन 6 का इलस्ट्रेशन बी है, इलस्ट्रेशन बी. Section 110 of the Evidence Act deals with option number C, burden of proof as to ownership. Section 113A of the Evidence Act deals with option D, presumption as to abatement of suicide by a married woman. The Supreme Court has legalized living wills and passive euthanasia subject to certain conditions in the case of Aruna Ramchandra Shanbog versus Union of India 2011. तो राइट आंसर हो जाएगा ऑप्शन नंबर ए. Article 310 of the Constitution mentions about option number D, doctrine of pleasure with reference to civil servants. Right to know the antecedents of the candidates in the election flow from Article 19 Clause 1 Subclause A. तो राइट आंसर हो गया ऑप्शन नंबर ए. In the preamble of the Indian Constitution, the expression liberty is followed by the words option number B of thought, expression, belief, faith, and worship. The plea bargaining is applicable only in respect of those offences for which punishment of imprisonment is up to a period of 7 years. तो हमारा राइट आंसर हो गया ऑप्शन नंबर ए. और इसके लिए आपको रिफ़र करना होगा CRPC के सेक्शन 265A. From a plain reading of Section 195 CRPC, it is manifest that it comes into operation at the stage when the court intends to take cognizance of an offence under Section 190, subsection 1 CRPC, and it has nothing to do with the statutory power of the police to investigate into an FIR which discloses a cognizable offence. In other words, the statutory power of the police to investigate under the code is not in any way controlled or circumscribed by Section 195 CRPC. This was held by the Supreme Court in the case of option A, Nalini versus State of Tamil Nadu, option B, Raj Singh versus State 1998, option C, Shamsher Singh versus State of Punjab, option D, State of Himachal Pradesh versus Tara Datta. देखने में तो ये चारों ऑप्शन ही सही लगते हैं, तो इसीलिए हम इसका कोई आंसर बता नहीं रहे हैं, इसका ऑफिशियल आंसर के लिए वेट किया जाए. The question is whether A owes B rupees 10,000. Which of the following statements are relevant under Evidence Act? Option A, the facts that A asked C to lend him money. Option B, D said to C in A's presence and hearing, I advise you not to trust A, for he owes B 10,000 rupees. Option C, A went away without making any answer. तो ये तीनों ऑप्शन करेक्ट है, तो हमारा राइट आंसर हो जाएगा ऑप्शन नंबर डी, ऑल ऑफ द अबव. और इसका रेफरेंस मिलेगा आपको इंडियन एविडेंस एक्ट के सेक्शन 8 में और इलस्ट्रेशन जी. सेक्शन 8 का इलस्ट्रेशन जी. सेक्शन 8 है मोटिव, प्रिपरेशन एंड प्रीवियस और सब्सिक्वेंट कंडक्ट. So much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered by the police, may be proved under Section 27 of the Evidence Act. तो राइट आंसर हो गया हमारा ऑप्शन नंबर सी. When the court has to form an opinion upon a point of foreign law or of science or art or as to identity of handwriting or finger impressions, the opinions upon that point of persons especially skilled in such foreign law, science or art or in questions as to identity of handwriting or finger impressions are relevant facts. This is under which section of the Evidence Act? The right answer is option number B, section 45. A intentionally and falsely leads B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterwards becomes the property of A and A seeks to set aside the sale on the ground that at the time of the sale he had no title. He will not be allowed to prove his want of title. Which section of the Evidence Act is applicable? तो राइट आंसर इज ऑप्शन नंबर सी, सेक्शन 115. और ये जो इलस्ट्रेशन दिया हुआ है इसके लिए आपको रिफ़र करना होगा इंडियन एविडेंस एक्ट का इलस्ट्रेशन. इंडियन एविडेंस एक्ट का इलस्ट्रेशन जो सेक्शन 115 में दिया हुआ है, स्टोपेल. The Arbitration Act 1996 repeals option A, the Arbitration Act 1940, option B, the Arbitration Protocol and Convention Act 1937, option C, the Foreign Awards Recognition and Enforcement Act 1961. ये तीनों एक्ट को रिपील करता है 1996 के एक्ट. तो ये तीनों आंसर सही है, तो हमारा ऑप्शन नंबर डी करेक्ट हो जाएगा, ऑल ऑफ द अबव. और इसके लिए आपको रेफर करना होगा आर्बिट्रेशन एंड कंसिलिएशन एक्ट 1996 का सेक्शन 85. सेक्शन 85 जो है रिपील एंड सेविंग्स. पार्लियामेंट में बाय लॉ एस्टैब्लिश एडमिनिस्ट्रेटिव ट्रिब्यूनल्स अंडर विच आर्टिकल ऑफ द कॉन्स्टिट्यूशन? आर्टिकल 323A. तो राइट आंसर हो गया ऑप्शन नंबर बी, आर्टिकल 323A. The Bar Council of India has to lay down the standards of professional conduct and etiquette for the advocates under Section 7, subsection 1, clause B of the Advocate Act 1961. तो राइट आंसर हो गया ऑप्शन नंबर बी. According to Section 49 of the Advocate Act of 1961, the Bar Council of India has power to make rules. Option A, qualifications for membership of a bar council and the disqualifications for such membership. Option B, The class or category of persons entitled to be enrolled as advocates. Option C, the standards of legal education to be observed by universities in India and the inspection of universities for that purpose. ये तीनों करेक्ट है, तो हमारा राइट आंसर हो जाएगा ऑप्शन नंबर डी, ऑल ऑफ द अबव. इंडिया, दैट इज भारत, शैल बी अ यूनियन ऑफ स्टेट्स. तो राइट आंसर हो गया ऑप्शन नंबर सी, यूनियन ऑफ स्टेट्स. और इसके लिए आपको रिफर करना होगा कॉन्स्टिट्यूशन ऑफ इंडिया. इंडियन कॉन्स्टिट्यूशन के आर्टिकल 1 क्लॉज 1 में, आर्टिकल 1 का टाइटल है नेम एंड टेरिटरी ऑफ द यूनियन. In MC Mehta versus Union of India, AIR 1987 SC 1086, Sri Ram Fertilizers case, the court held that, इसका राइट आंसर हो जाएगा ऑप्शन नंबर ए, इन escape of toxic gas, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exception which operate vis-a-vis the tortious principle of strict liability. According to Environmental Protection Act 1986, environmental pollutant means, right answer है ऑप्शन नंबर सी, any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to environment. और इसका रेफरेंस मिलेगा आपको इन्वायरमेंट प्रोटेक्शन एक्ट 1986 के सेक्शन 2 में. सेक्शन 2 है डेफिनेशंस. सेक्शन 2 का कौन सा क्लॉज? क्लॉज बी. Section 2, Clause B of Environment Protection Act 1986. National Green Tribunal cannot exercise its jurisdiction with reference to Option A, Wildlife Protection Act 1972. Option B, Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. ये दोनों ऑप्शन ए एंड बी सही है, तो हमारा ऑप्शन नंबर डी करेक्ट हो जाएगा, बोथ ए एंड बी. An attempt to acquire sensitive information such as usernames, passwords, and credit card details, and sometimes indirectly money, by masquerading as a trustworthy entity in an electronic communication is known as phishing. तो हमारा राइट आंसर हो जाएगा ऑप्शन नंबर सी, phishing. Under Section 82 of the Indian Penal Code, nothing is an offence which is done by a child under the age of 7 years. तो राइट आंसर हो जाएगा ऑप्शन नंबर बी, 7 years. R versus Dudley and Stephen stands for the principle that option A, killing an innocent life to save his own is not a defense and necessity cannot be pleaded as a defense against murder. तो राइट आंसर हो जाएगा ऑप्शन नंबर ए. The utility of public interest litigation, option A, liberalized locus standi, option B, the proceedings are non-adversarial, option C, procedural requirements are liberalized. ये तीनों करेक्ट है, तो ऑप्शन डी हमारा राइट आंसर हो जाएगा, ऑल ऑफ द अबव. The petitioner, a professor of political science who had done substantial research and deeply interested in ensuring proper implementation of the constitutional provisions, challenged the practice followed by the state of Bihar in promulgating a number of ordinances without getting the approval of the legislature. The court held that the petitioner, as a member of public, has sufficient interest to maintain a petition under Article 32. This relates to the case of which case? इसका राइट आंसर हो जाएगा ऑप्शन नंबर बी, DC वधवा वर्सेस स्टेट ऑफ बिहार, AIR 1987 SC 579. Where a legal wrong or a legal injury is caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal right, or any burden is imposed in contravention of any constitutional or legal provision or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of persons by reasons of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief, any member of public can maintain an application for an appropriate direction, order, or writ in the High Court under Article 226, and in case any breach of fundamental rights of such persons or determinate class of persons in this court under Article 32, seeking judicial redress for the legal wrong or legal injury caused to such person or determinate class of persons. Justice Bhagwati in the case of People's Union for Democratic Rights versus Union of India. तो ऑप्शन नंबर ए हमारा राइट आंसर हो जाएगा. Imposition of compensatory costs in respect of false or vexatious claims or offences is dealt under section 35A of CPC. तो राइट आंसर हो जाएगा ऑप्शन नंबर बी. Which provision under the Code of Civil Procedure deals with substituted service of summons upon the defendant? तो राइट आंसर है ऑप्शन नंबर सी, ऑर्डर 5 रूल 20. Among other things, the function of Bar Council of India includes laying down standards of professional conduct and etiquette for advocates. Under which section of the Advocates Act? Section 7. Option A हमारा right answer है. Section 7. According to Justice Abbott Perry, what are the 7 lamps of advocacy? Right answer मिलेगा आपको ऑप्शन नंबर बी में. Honesty, courage, industry, wit, eloquence, judgment and fellowship. मिनिमम नंबर ऑफ डायरेक्टर्स इन अ पब्लिक कंपनी 3. ऑप्शन ए हमारा राइट आंसर हो जाएगा 3. और इसके लिए आपको रिफर करना होगा कंपनीज एक्ट 2013 के सेक्शन 149. सेक्शन 149 सब सेक्शन 1 क्लॉज ए, कंपनी टू हैव बोर्ड ऑफ डायरेक्टर्स. तो पब्लिक कंपनी में मिनिमम डायरेक्टर्स होंगे 3, जो कि दिया हुआ है हमारे ऑप्शन नंबर ए में. An associate company in relation to another company means, आपको राइट आंसर मिलेगा ऑप्शन नंबर बी में, अ कंपनी इन विच that other company has a significant influence but which is not a subsidiary company of the company having such influence and includes a joint venture and a company. Section 66A of Information Technology Act was held unconstitutional in the case of Shreya Singhal versus Union of India. तो हमारा राइट आंसर हो गया ऑप्शन नंबर सी. अ टीचर इज नॉट अ वर्कमैन विद इन द परव्यू ऑफ इंडस्ट्रियल डिस्प्यूट्स एक्ट हेल्ड इन द केस ऑफ ए सुंदरम्बल वर्सेस गवर्नमेंट ऑफ गोवा. तो इसका राइट आंसर हो गया ऑप्शन नंबर सी. अकॉर्डिंग टू फैक्ट्रीज एक्ट, चाइल्ड मीन्स अ पर्सन हु हैज़ नॉट कंप्लीटेड हिज 15th ईयर ऑफ एज. तो हमारा राइट आंसर हो गया ऑप्शन नंबर ए. According to Income Tax Act, zero coupon bond means a bond, option A, issued by any infrastructure capital company or infrastructure capital fund or public sector company or scheduled bank or on or after the first day of June 2005. Option B, in respect of which no payment and benefit is received or receivable before maturity or redemption from infrastructure capital company or infrastructure capital fund or public sector company or scheduled bank. Option C, which the central government may by notification in the official gazette specify in this behalf. Option D, all of the above. तो राइट आंसर हो जाएगा ऑप्शन नंबर डी, ऑल ऑफ द अबव. और इसका रेफरेंस मिलेगा आपको इनकम टैक्स एक्ट 1961 के सेक्शन 2 में, सेक्शन 2 के क्लॉज 48 में. Provisions relating to GST are inserted in the Constitution by the Constitution 101st Act 2016. तो राइट आंसर हो गया ऑप्शन नंबर ए. आर्टिकल 279A inserted in Constitution by Constitution 101st Amendment Act 2016 with effect from 12/9/2016 यानी 12 सितंबर 2016. Suits by indigent persons is dealt under Order 33 of CPC. तो राइट आंसर हो गया ऑप्शन नंबर बी. Res gestae, relevancy of facts forming part of same transaction is dealt under Section 6 of the Evidence Act. तो राइट आंसर हो गया ऑप्शन नंबर ए. The definition of money under GST law does not include option B, currency held for numismatic value. Numismatic क्या होता है? Numismatic means relating to or consisting of coins or medals. Under Article 279A, GST Council is constituted by option C, the President. The definition of contract is defined under Section 2H of the Indian Contract Act. तो राइट आंसर हो जाएगा ऑप्शन नंबर बी, सेक्शन 2 क्लॉज H. The Hindu Succession Amendment Act HSAA 2005 provides for women co-partner rights at par with men. तो हमारा राइट आंसर हो गया ऑप्शन नंबर ए. सेक्शन 25 ऑफ द हिंदू मैरिज एक्ट प्रोवाइड्स फॉर परमानेंट एलिमनी एंड मेंटेनेंस. तो राइट आंसर हो जाएगा ऑप्शन नंबर बी. A Hindu wife had been living with her children and all the children had been brought up by her without any assistance and help from the husband many years. The wife was entitled to separate residence and maintenance under Section 18, subsection 2, clause A of Hindu Adoptions and Maintenance Act. तो right answer हो गया option number C. Requisites of a valid adoption. No adoption shall be valid unless the person adopting has the capacity and also the right to take in adoption. The person giving in adoption has the capacity to do so. The person adopted is capable of being taken in adoption, and the adoption is made in compliance with the other conditions mentioned in this chapter. It is mentioned under which section? It is mentioned under section 6 of Hindu Adoptions and Maintenance Act. तो right answer हो जाएगा option number A. According to the Muslim Women Protection of Rights on Marriage Act 2019, any pronouncement of talaq as defined under the act by a Muslim husband upon his wife by words either spoken or written or in electronic form or in any other manner whatsoever shall be void. तो right answer हो गया option number A, void. The UN Central Model Law and rules do not become part of the Arbitration Act so as to become an aid to construe the provisions of the Act. Held in the case of Union of India versus East Coast Boat Builders and Engineers Limited. तो right answer हो गया option number A. According to Section 7, subsection 4 of the Arbitration and Conciliation Act, an arbitration agreement is in writing if it is contained in option A, a document signed by the parties, option B, an exchange of letters, telex, telegrams, or other means of telecommunication which provide a record of the agreement. Option C, an exchange of statements of claim and defense in which the existence of the agreement is allegedly by one party and not denied by the other. तो right answer हो जाएगा option number D, all of the above. Waiver of right to object deviance from arbitration agreement is mentioned under which section of the Arbitration and Conciliation Act? It is mentioned under section 4. तो right answer हो जाएगा option number B. दोस्तों इस वीडियो को प्रिपेयर करने में बहुत मेहनत लगा है, बाकायदे एकदम तरीके से रिसर्च करके क्या क्या कौन से सेक्शन से किस एक्ट से कौन सा प्रोविज़न लिया गया है, किस क्वेश्चन में क्या हो एप्लीकेशन होगा, बाकायदे तरीके से एक्सप्लेन करके हम वीडियो बनाए हैं. तो प्लीज़ इस वीडियो को लाइक कर दीजिए और चैनल को भी सब्सक्राइब ज़रूर कर लीजिए. थैंक्स फॉर वॉचिंग दिस वीडियो.